just beginning your journey in law school or preparing to participate in your very first moot court competition, today's session will provide you with valuable practical insights. We'll begin in just a moment. Before we formally begin, let me ask you a few questions. Have you ever wondered why exactly is moot court? What exactly is the moot court? How do students prepare for moot court competitions? What makes a strong memorial and an effective oral argument? How can one confidently present arguments before a bench? Moot courts are one of the most important aspects of legal education. Important aspects. They help law students develop research skills, legal reasoning, drafting abilities, public speaking, and courtroom etiquettes. Today's session on moot court basics will introduce us to the fundamentals of moot court competition, including their structure, preparation strategies. We are confident that today's discussion will give everyone a strong foundation and encourage you to actively participate in moot court competitions. Today's session is organized by the Collective Counsel, a platform dedicated to bridging the gap between legal education and practical learning through mentorship opportunities, skill based programs, career focused training. Our objective is simple to help law students and young legal professionals develop practical skills, gain meaningful exposure, and prepare themselves for successful legal careers. It's now my privilege to introduce our esteemed speaker for today's session, Advocate Sahil Rathod, sir. Sir is an accomplished legal professional with extensive experience in litigation and legal advocacy. Through his guidance and practical insight, he has mentored aspiring law students in developing advocacy skills, understanding courtroom procedures, and excelling in moot court competitions. On the behalf of the Collective Counsel, I extend a warm welcome to you, sir. Without further delay, I request Advocate Sahil Rathod, sir, to kindly take over the session. Over to you, sir.
Thank you so much, Noor. Can you please confirm if I am audible properly?
Yes, sir, you are audible very much.
Thank you so much. So, welcome everyone in this today's education program. Myself, Advocate Sahil Rathod. So, without timing our waste, we directly start with the today's. We cannot say lecture, but introduction or familiarization to the moot court or what is moot court. So, my first question would be: has anyone here argued a case, even formally, informally, anything? Sure. So, yeah, I see certain answers. You have participated. Good night. So, see, now moot court, what we generally understand from the book language, like a moot court is just a second.
Yes, sir.
Yes, sir.
So, a moot court is a simulated court proceeding in which participants argue a hypothetical or constructed legal problem before a bench of judges exactly as they would before a real court. For example, the national flag issue, which was before the Supreme Court, that should it be played before the screening of the movie in a theater or not? Does that involve patriarchy, patriotism? So that issue can be considered in a moot court, and students participate in that. So now the word moot, which itself comes from the Old English gemot, meaning an assembly for debate. Historically, an issue that was moot was one open to argument, not one that was irrelevant. See, now in moot court, the facts of the case are, as I earlier said, it is a hypothetical case or it is a constructed legal problem, a real problem, a hypothetical case. In that, students are mainly expected to understand the case, understand the law, understand the interpretation. Now, when you start, we usually encourage all the students from the first year of their law college, they should start mooting, start preparing, start researching. For that purpose, you will understand even without reading or studying the interpretation of statutes, which is a different subject in many of the universities. You will directly understand the practical purpose of it. How do you interpret any case law? How do you interpret any judgment? Any quote delivered by any judge, how it is relevant to that case, how other case laws, how precedents are relevant to your case. That everything will include in the interpretation. So here students, as a student, you are expected to understand the interpretation, understand the law which is applicable on your case, and understand the facts. Then only you can be a better mooter and you can present your case perfectly. See, importance in legal education of a moot court, we can say that it is not an extracurricular activity. Many of the universities have put that under extracurricular, but it is not. It is directly connected to our field. It is not an extracurricular activity. You should understand this directly. It is where theoretical law becomes applied lawyering. It builds four skills simultaneously that no classroom lecture can. Firstly, legal research and the ability to locate, read, and supply statutes, precedents, and secondary sources. Secondly, persuasive writing, which you can show it in your mood, in your memorial, in the written memorial. So condensing law and fact into a structured, readable memorial. So whenever you draft a memorial, you think that what the judge will think after reading this memorial. Will he have any doubts? And if he will have any doubts, what doubts can be curated from that? Third is oral advocacy, which is your oral presentation of your facts, of your laws, your answers to the judges, and the conclusion of your case. How you are presenting, which side you are presenting, and how your arguments are related to that side. See, oral advocacy is thinking on one's feet and responding to hostile questioning. And the fourth is professional temperament. Me, as I'll give you my real example, when I was invited in my own college as a judge, I my first thought was that while I was a student, I was mooting. I was grilled intensely. I was asked questions about any irrelevant facts, anything other than my moot. And my main, when I started judging, my main thing was I should also grill the students, because grilling it basically tests your temperament and your patience and the ability to answer the judges. So that is basically composure, courtesy, and quick judgment under pressure. So in layman language, we say presence of mind. So what the judge is expecting, what he is questioning, and how you are answering without wasting any time. Now we will go to structure of a moot court. Can I get the next slide?
Hello, good evening, sir.
Good evening.
Sir, my name is Ritesh and I'm BLLB student. Sir, I'm really sorry I disturbed you this time. Actually, my important question, which thing is the most important in law field, theoretically and practically?
Ritesh, we have a different question and answer session at the end of this session. So
Oh,
if you can raise your question at that time, thank you so much. So today what we'll cover is introduction to moot court structure, the analysis, how to draft a memorial, oral arguments, courtroom etiquettes, evaluation criteria, and tips for success. So firstly so I have introduced the moot court. Now we go to structure of a moot court. So in the structure there are three main things: the judge, the petitioner and respondent, and the courtroom etiquettes. This is the structure of moot court. So the judge, which is we address them as a bench. Bench is usually composed of 1 to 3 judges, depends on the size of the moot court or the college which is organizing it. Judges play a dual role basically. They evaluate the arguments and they actively test them through questions. See, judges are not passive listeners. a good judge interrupts continuously. He challenges your assumptions and pushes you towards the weakest point of your case. So when a moot court is prepared, when the facts are prepared, it is prepared in such a way that one side is weak in that. And uh, in most of the moot courts, there are two rounds where you represent both the petitioner and the respondents. So you have to face that weaker side as well. And in that case, judges' questions are most important because, as per facts, you are weak. Your case does not stand out. For example, your client is guilty or your SLP is not maintainable. But in that case, also judge won't say you direct that your petition is not maintainable. You go from here, or your petition is dismissed. He will question you. He will put n number of questions to test your research, to test your understanding. This is what main moot court is. It is not about winning and losing. This is not a general statement. It is very deep statement that I am again making. It is not about winning and losing. So now in uh, so the judge will evaluate both your legal mind and your courtroom conduct, your etiquettes. And now comes to you, that is counsels, the petitioners and respondents. So most of the colleges, they allow you to have a team of three. There are two speakers and one researcher. In some of colleges they allow four, and in some they allow two only. But compulsorily there should be two speakers, which is also called as two mooters. So now each side typically fills two or three counsel, often a lead counsel who opens and handles the primary issues, and a junior counsel or the second speaker who covers secondary issues and rebuttal. So the if I am assuming that everyone here knows who is a petitioner and who is a respondent or appellant or respondent. So now the third thing is courtroom etiquette. See, etiquette is addressing the bench, introducing yourself, addressing their questions, addressing the answers, the rebuttal, the sir rebuttal, and the judgments which you are referring, how they are related, you introducing the judgments, making a base, and you making understand the judges. These all will cover under the etiquettes. So you usually refer the judges as my lord, your lordship, your honors. But now in Indian judiciary, they have even started addressing the judges as sir and ma'am. Yeah. In etiquettes, there is one important thing, very, very important thing, which even I have faced while a mooter, and I have experienced that when I was judging. If I, as a judge, am asking any question, I should not be interrupted at all. As a mooter, you should not interrupt the judge anytime, any moment. Even if you think that your earlier question, the judge's earlier question is not answered, you listen the second question, you write down the first question, and then you go to the first question. You should not interrupt the judge anytime. That is our temperament level, because we have to mark you on that. Because the judges give you marks on that, you should not interrupt the judge. Yeah, so etiquettes include this. Now we go to the third thing, that is moot problem analysis. Can we have the next slide? Next slide, please. Next slide. The other one, the up one before the fourth point. Yes, this slide. I'll give you one example. I had in one of my moods, international moods, there was one issue. It was a criminal law thing. The accused and the victim, they were on the eighth floor. They had a fight. They were into a domestic fight. The accused had a gun in his hand, and the other party who was in front of him, they were having a fight. And by mistake, accused fired the bullet. It didn't hit the other person who was in the room, but it hit the person who was on the ninth floor. Now, there were two theories in this. that the accused went on ninth floor, he shot him and he came back down. And other theory which I had introduced before the judges, that the accused was falling from the ninth floor. Due to some or the other reason, he was falling from the ninth floor, and when the accused had fired from the eighth floor, that bullet shot him in the air without any intention. So the the issue was, who was the culprit? Is it proved or not? But my interpretation was something else, that this is also a possibility when there are no natural witnesses to depose. So understanding the moot problem with the facts, firstly, with the facts. When you understand the facts properly, you can recognize, you can highlight the loopholes where you can divert your case, where you can add more gray area so that you can get that case in your side, even if you are even if you are representing the accused. So in this case, we introduced a new theory, and then that theory was entertained more than what was written in the memorial, in the moot problem. Yeah, this coupled with the question of law. Now, question of law here was IPC 302 or IPC 300, culpable homicide or murder. What was it exactly? We diverted that to an accident, and the judges were very impressed with that. So the main thing is, you understand the mood problem, you understand the you understand the law related to that, and there are issues. First issue has to compulsorily be, is your petition, is your SLP maintainable or not? Because mood problems are usually designed as if you are representing in the High Court or in the Supreme Court under their extraordinary jurisdiction or under the writs. So as you can read here, like, it's a natural question. It will have 3 to 5 issues addressing each and every point, and there are certain times when when the organizers expect you to draft an issue. So you should draft that issue in such a way that it is neutral from both the sides. So see that example. There is an example whether the arrest was in violation of due process. So even state can argue, and even the accused can argue on this point. But if you address this question as the arrest was illegal, so it is from the side of the accused only. Yeah. So a good moot memorial typically frames 3 to 5 clean issues, each phrased as a neutral question. For example, what I quoted here. Moot problem analysis will also include what other laws are applicable. In the moot problem, they must have given that IPC is applicable, this section of IPC is applicable, this section of CRPC is applicable, or BNSS or BNS. But in certain time, you can also introduce other special laws. For example, in Maharashtra, there is the Organized Crime Act. So now you would have seen in the news as well, the FDA chief, he has introduced this thing that whenever there will be any violation of that act, this act also will be applied. Yes. So this act also will apply. This is a special law, a state law. But the one who researches properly, he will understand if this law is applicable or not. This will be a surprise element for your other party. So when they draft this moot problem, when they will draft the memorial, I will draft my memorial as per petitioner. Other side will draft it as per respondent, and on the basis of moot problem only. But I, as petitioner, if I'm challenging the acquittal, I will also think that this act is also applicable on this. I'll write that everything in the my memorial. When the memorial section happens, they get a surprise element that we didn't explore this side as well. So you have an upper end there. So that is why you should always try to identify the issues of law and fact simultaneously. Yeah. Next slide, please. Next point, we have memorial drafting. So you will get the format of the memorials. You have everything online, and you usually get the structure of memorials in the moot propositions, in the rules and regulations. But again, we go through that. So cover page, will include team code, your side represented, the court, the case title, and the color code as well. Yeah. See, moot court etiquette is also connected to the memorial drafting. Why? Because from the first page, what I had experienced, from the first page, they didn't write the team code only. So now I am surprised that who am I marking? What marks should I give and whom should I give? So always remember that your representation, how is it important when you start, when you approach the bench, you stand up and you ask the bench, the council seeks permission to approach the dais. You approach the dais. Then the first thing is you address the bench. You take permission to address the bench as your honors or collectively your lordship, sir or ma'am, anything. Then you introduce yourself as well. That I am, we are the petitioners. I am, this is my team code. I am the petitioner number one. I am the speaker number one. My co-counsel is speaker number two. Then they identify you that who you are representing. Many times judges do confuse the parties, and they simultaneously they fall into arguments of the other party, and they agree that the other side is correct. This should not happen. You understand who you are. You prepare that mind. Next thing is index table of contents. Table of contents will include your very short synopsis. For example, on this page, this thing is there. For example, first page is list of abbreviations and index of authorities, then statement of jurisdiction, facts, issues, summary, and your arguments. Third thing is list of abbreviations and index of authorities. Um, See, to reduce the size of the memorials to 28 or 20, 34 pages, what we generally do is if we can write example as eg dot in abbreviation thing, I am ultimately reducing the size of my memorial, which will help the judge to understand my memorial properly, because it is not so lengthy that he has to read each and everything. So list of abbreviations is very much important. You use abbreviations in the entire memorial. It is very important you use it properly. And the index of authorities. Authorities is the cases, the statutes, the articles you are relying on, and the precedents. So you should list out all the authorities. Now the main question: what number of authorities do we rely on? There are n number of articles on one issue. There are limited statutes you can refer to. There are thousands of cases. There are n number of cases which you can rely. Even one sentence of that judgment, you think that this is in my reference. This will support my case, so I should mention this. This is not at all necessary. You should understand that wherever the interpretation of law is involved, coupled with facts, you should find one such case law that is directly hitting your case, that is directly proving your case. No need to mention another case. The less number of judgments, the less headache you have. I personally feel when the parties, when you guys draft the memorial, when you argue that in this case this happened, in this case Supreme Court decided that, this and all, I think that you have read that much only. So every time I ask that participant what are the facts of the case, and when they try to recollect the facts, they are blank. They do not know the facts. They have just read the ratio and they have relied on that. If the facts of the case are not relevant, how will you rely on that case? If it is a reportable judgment where there is something, a uh, new interpretation has been introduced by the Supreme Court, we can rely on that. If it is a constitutional case, if it is about right to privacy, anything. But when it comes to murder, when it comes to rape, when it comes to special enactments, generally there are very much less number of judgments which directly hit your case, your proposition or the facts. So keep this in mind. You should read the entire judgment and then refer that judgment before the court, before the bench. If this question hits you, if you do not know the answer, you can say that my researcher will address this. This is going to be a negative part. But if you are not at all able to answer, you can push it on your researcher. because research is also expected to know the entire case, entire memorial, everything. But if you know, address that question in very brief and very short line, 3 to 4 lines enough, that this is the facts of the case and this has been decided. That's it. The judges will understood that you have researched, and they won't go on that part again, because in the marking table there is one point that reliance on the authorities and the facts of the authorities. So marks are also given on that. Next, we come to statement of jurisdiction. Statement of jurisdiction for High Court is 226, 227. When you go to writ petition, when you want to exercise the extraordinary jurisdiction of any High Court, you go to 226, 227 of Constitution. When you want to writ, you want a writ from the High Court, you go to 32. And then under special acts, under various acts, there are directly sections under which you can file an appeal. The writs which are given under 32, you can go to Supreme Court under 136, 137, 138, everything. So these are usually statement of jurisdiction. Jurisdiction means how this court has power to enter in this case. That's it. Not a very much difficult question to answer. Then comes statement of facts, which is a neutral chronological narrative drawn only from the moot proposition. You should not introduce any new fact in the memorial. No new fact in the memorial. If the statement is against you, write it. If it is in favor of you, write it. Do not alter the moot proposition. Do not add anything. Do not subtract anything. The new facts, which I gave an example earlier, I had done that orally, and then it was entertained. Then the issues raised, which you will directly get. Then comes a summary of arguments. Summary of arguments. Um, for example, the first question usually comes is this writ petition maintainable or not? Consider that I have filed a writ of mandamus to give directions to any public authority. And first issue is if this writ is maintainable or not. From petitioner side, of course, I'll say this is maintainable. These are the points, these are the facts, these are the case laws of Supreme Court, these are the powers of this honorable court under which this is maintainable. Right? Summary of arguments. See, when you argue the case, you have a conclusion to go on. For example, if I'm arguing that my case is maintainable, I rely on these all things. Then in conclusion, I again say that as per this point which I relied on, and as per the facts of my case, this honorable court has the power to entertain this case. This is the conclusion remark. You should always write this in summary of arguments, which will explain that the summary of the argument, that what you are arguing, and the conclusion, what you exactly want from this court. Arguments advance will include everything, case laws, citations, and papers, and everything. But summary of argument, you should always write it properly. As judges, we expect that we only read summary of arguments, and we want to understand that what the counsel is relying on. So it is a concise preview of each argument's conclusion. Then arguments advance comes the substantive legal reasoning issue by issue. So first issue, second issue, you write judgments and everything, whatever you rely on, whatever the material is, and the prayer. Now the prayer should be very specific, like what exactly you want from the court. If it is maintainability, I will say it is humbly prayed before the honorable court that this honorable court may be pleased to pass an order or allow this petition as maintainable or declare this petition as maintainable. This is my very specific prayer that I want this from this court. I won't say that allow this petition because this. Again, you go to arguments, not necessary. If even if it is one line, write that much only. Now, what common mistakes you should avoid? Introducing facts that do not appear anywhere in the proposition, citing authorities without pinpoint references or without confirming they remain good law. What do you mean by they remain good law? Is, for example, there are various judgments which were, you know, decided earlier by the previous benches or previous judges, but now they are overruled. So the judgment which overruled that we will say that that remains a good law, because whatever is overruled, that is not law anymore. So good law means what is in effect today. Then writing arguments as one-sided advocacy essays instead of structured legal synopsis. For example, rule, application, conclusion. Don't fall into the traps that I need to argue each and everything. I need to write everything in my memorial. What if the judge won't listen to my arguments? Then he should know at least what I have written. So I'll write everything in my arguments. No. Your arguments advance should be very, very precise, on point, no any other points which will create doubt in the judge's minds. Next thing, there are rules which have been they have introduced that the formatting of the memorial should be in this way only. The spacing, the format, the font, the size should not ignore that. And any prayer that does not match the relief which you have actually argued should be avoided from the memorial. Now we'll come to oral arguments. Next slide, please. For example, I am petitioner. I stand on my place where I am sitting, and I just when they say you can start, so I stand up on my place and I say the council seeks permission to address the bench. So I go address the dais. So I go on the dais. Then first permission I take is how do I address you? So council seeks permission to address the bench as your honors, your lordships, whatever you feel. So then you introduce yourself. Then you say that I'm petitioner number this, or I'm referring the I'm representing petitioner. Then you introduce the facts of the case. Facts of the case should not be read out. Whatever you have written, you should not read that. You should introduce the facts in very, very short thing, 4 or 5 lines max. The judge should understand that fact that this is the basic case and this is why they have come before this court. Your presentation skills starts from here. Encourage the judges clearly. No hurried delivery. Do not think that, oh, my time is moving, I need to cover everything, so I am speaking very, very fast that even judges are not interested in hearing my case. Stop that. Eye contact with each judge. If the judge is asking you a question, eye to eye, he will have a confidence that he is listening to you, that you are listening to him, and his questions are being addressed properly. And confident, no aggression at all. If the judge is saying that your case law does not match or is not reliable here, do not show any aggression. Humbly accept that and set aside and side your argument for that part and move to next thing. And your body language, standing on one leg, uh, lying down towards or judges, and uh, doing anything which is irrelevant in a courtroom. You should always avoid that thing. Now, time management, many times time management, we forget that we are also bounded by the time management. See, oral arguments are very precise. 15 minutes to one side, 15 minutes to other side, and 5 minutes reserved for rebuttal and sub-rebuttal. You should practice yourself at home in front of the mirror that you are completing the arguments in your time. Because you will hardly get 30 to 40% of your entire time to present your case, and the rest of 64 or 70% will be the judges questions only, because judges wants to know how much have you researched and what you know about the proposition, not what you have written in the memorial, because your memorials are marked differently. Now they want to test your patience and your presentation skills. So focus on time management. You can allot time to both the petitioners. For example, if I am addressing only one issue, I'll take 4 minutes. And if my co-counsel is addressing two issues, I'll give him 8 minutes or 9 minutes, and I reserve some time as buffer time, that if I exceed my time, so this should be buffered. And oral arguments, thirdly, include, which I'm saying again and again, is handling the questions from the judges. This is where most marks are won or lost. See, there is core rule. Answer the question asked directly and first before returning to prepared submissions. See, answer, explain, and return. This is the three thumb rule. Address the question, answer it, explain your answer, and return to the original submissions. Return to the facts or wherever you were stuck. And when judges are questioning, do not try to explain or do not try to dive into it. If you dive, he is going to dive. Answer your questions in one line. If judge is asking, is your petition maintainable? Yes. This is his question. Is your maintainable petition? Is your petition is maintainable? Yes or no is the answer. Just answer yes. If he's asking how or why, then go into explanation. Why is it maintainable? You are going to save your own time. Next slide, please. Now we go to courtroom etiquettes. So dress code, formal attire, everything is written, everything is informed to you prior to the moot probation. Like if you can read Advocates Act or rules made thereunder, you will get the dress code as well. What advocates are expected to wear in the court. Addressing the bench respectfully. One thing, uh, you must have heard in recent thing, um advocate Harish Sarvi, uh, Harsh Sarvi, I guess. I don't remember his name. He was arguing one case in the Supreme Court, and the opposite counsel was Advocate Ponda. He's a senior advocate. He practices in Bombay. When they were arguing, they made some statements which are derogatory to each of them. Harish Sarvi, I'm so sorry. So they made statements which were derogatory to each of them, and he directly, senior advocate Ponda sir directly said that you address to the bench, not to me. Then that was aggression which he showed, that I am not your colleague, I am opposite party, we are before the court, you address the court. But again, next second, when the matter is over, you will see they both enjoying a cup of coffee together. So you should not think in this way that my opposite counsel is my enemy. Always refer them as my colleagues, my co-counsels, my friends, like that only. Because ultimately you are there for a competition. You are not known to each other directly. If you politely handle this thing, which is usually seen in rebuttal and sir rebuttal, I am addressing his questions, I am answering his questions, and then I'm again making objections that no, you are wrong. I should not say this. You are wrong. You should not refer to your learned counsel, your friends, in a direct way. Always say my learned counsel, my friend, my co-counsel, my colleague. That this will come under courtroom etiquette. Next thing, uh, as I said, the structure of memorial, which goes to let us start from statement of jurisdiction, statement of facts, statement of issues, then go to arguments. Take permission of the court. If if you have addressed the facts, then take permission of the court that if your lordship, my lords, if the bench, if the honorable bench is fully conversant with the facts, the council seeks permission to proceed with the statement of arguments. Take permission for each and everything. This will ensure you that the judge is on the same page what you are on. Otherwise, you are on page number 10, he is still reading page number 2, that what the council was speaking, I don't know. This is going to save a lot of time. So this will include courtroom etiquettes. Now, how evaluation takes place. Please go to evaluation slide. Evaluation of your criteria usually is the marks on the memorial, the marks on the presentation, and the research and citations or the authorities which you have relied on. So the quality of memorial will usually be, already marked before even you start arguing. It is marked already. The memorial is marked. So it is judged on legal soundness, the structure, clarity of issues, if it is correct, the citations. The citations will also the format of citation is the cause title, this versus state of this versus Union of India, in bracket the citation. Citation means the book in which it is referred, AIR, Manopatra, SCC. So now we have online citations. So write everything. Then oral advocacy is judged on the command of facts and laws. Command means if they are asking you any question, you have a ready answer because you know the facts. If you didn't read that, then you pass on that to your co-counsel. This will deduct marks. So you should know each and everything. The persuasiveness, composure under questioning, and courtroom demeanor. And third thing, research and citations. This is something surprising to me as well. Like when I was a researcher in my third moot, I was asked by the judge to come on the dais and address the issue. At that time, I just thought that a researcher has to do nothing. My basically my work is back end. I'm not going to face the questions. But I was wrong. I was asked questions. I didn't. I was not able to answer the questions properly because I was not aware with each and everything what was written or each and everything what was prepared by the uh, mooters, and we lost marks. And we ultimately we are not selected for the next round. So researcher also should consider themselves as a backup. They should know each and everything, whatever is being arguing right now, and whatever is going to be argued afterwards. For example, if I'm relying on any citation, the researcher's work is to pass on that the copy of that judgment to the bench. So researcher should also be attentive. Uh, Now there are some tips for success. Is team coordination, or what I just explained, that both the motors and the researcher. If you have participated in any moot, you must have observed that motors, if they're stuck onto any point, they have this much chits kind of, or the piece of paper. They write their answer and pass on to the mooter who is mooting or who is arguing the case. This is team coordination. If I do not know the answer, my co-counsel knows the answer. It is allowed to pass a chit or by the researcher. And because I am addressing the bench, I am not able to answer. Then they pass me the chit, and I read the chit. I immediately get that point. Oh, this is the answer. Then I answer this. This shows team coordination. So you should prepare each other's questions and tag this line moot before the moot. So you must have a committee in your college, a moot court committee, including the professors and your seniors. Whenever you are participating in any national moot court, if you have prepared everything, ask them to be judge and conduct a demo moot for you. This will give you experience. This will give you an idea that what questions can come, and this will give you confidence as well. Next thing, you should practice sessions. Repeatedly read the judgments, what you're referring on, the facts, the laws, everything. So practice sessions with the mooters or with your partners will give you confidence. And third is the confidence building. So see, confidence building is basically the collective effort of all the participants, the backend team or the researchers or your friends, everything. So now one thing what I've observed is most of the colleges or most of the universities, they introduce or they organize moot courts very uh, having very simple format. Pick any Supreme Court judgment, pick any case, put that as a moot proposition, and go ahead with the proposition. But now the collective council has introduced a new thing, which I think that if I were a student now, I would have participated very actively. So they have introduced national bail advocacy competition, which will directly is going to address the bail part. So you must have read in uh, various posts, and you must have read various news as well, that this person got bail, that person got bail. You think, अरे इसने तो इतना बड़ा crime किया, इसको bail कैसे मिल गया? you dive into the judgment, go with the read the judgment of the bail, why the bail was you know why the bail was allowed. For example, there is a recent judgment wherein the the reasons for the arrest were not communicated to the accused, and on that basis the bail was granted. Even if he is accused of rape, he is accused of murder, if the procedure is not followed, there is part called default bail. So I would appreciate each and every participant here that you should participate in this competition. You will understand a lot of things. Yeah. Now, uh, anyone from collective council, if you want to.
Yes, sir, yes. Just 2 minutes. Noor just announced that thing.
Thank you so much, sir. That was genuinely an insightful session. I think today's discussion reminded all of us what a moot court is. It is never just about speaking well, it's about reading the facts carefully, researching the law, building a strategy, and then having a confidence to defend it. And I think that's exactly why hearing from someone like Advocate Sahil Rathod, who has served as the president of the Moot Court Society at Sinagar Law College, made today's session even more meaningful. Sir has worked closely with students, developing their advocacy skill, and throughout the session, one message came across very clearly that good advocacy begins long before you stand in front of the bench. On behalf of the Collective Council, thank you once again, sir, for sharing your time, your experience, and your guidance with all of us.
Absolutely. And while Sir was speaking, one thing really stood out to me. As law students, we spend years studying legal practice, prepare for exams, and maybe even participate in a few moot courts. But very rarely do we experience what legal practice actually feels like. Not just arguing, but preparing, thinking like a lawyer, analyzing a file, building a case, and prepare before you ever stand to speak. And that's exactly the thought behind the National Bail Advocacy Competition 2026. So, NBAC has been designed to recreate that journey as closely as possible. The competition unfolds across three progressive rounds. It begins with the document analysis and written bail memorandum round, where participants receive a realistic criminal case file, including documents like FIR, arrest memo, medical examination report, and supporting records, and prepare a professionally drafted written bail memorandum. So, those who qualify move to the next professional oral bail advocacy round, where fresh investigation material is introduced. Participants refine their legal strategy and present a live bail application before a simulated bench. And finally, the competition concludes with the final round, where participants argue a far more complex constitutional bail matter involving personal liberty, judicial discretion, and public interest. So rather than testing only how confidently someone speaks, NBC focuses on research, drafting, legal strategy, and advocacy together.
Exactly, and that's what makes NBSC different. It isn't just another advocacy competition, it has been designed as a practical learning experience. Beyond the competition itself, every registered participant will receive a certificate of participation, exclusive legal resources, access to a job simulation program in our cybercrime investigation and digital law practice, and an opportunity to be considered for internship opportunities with our legal partners. Outstanding performances will also be recognized through awards for Best Criminal Law Researcher, Best Written Mail, Best Written Bail Memorandum, Best Public Prosecutor, and Best Defense Counsel. But beyond the awards and recognition, what we hope every participant takes back is something more valuable: greater confidence, sharper legal reasoning, and a better understanding of what responsible advocacy truly demands. So, if today's session has inspired you to challenge yourself beyond the classroom, we genuinely love to have you as a part of inaugural National Bail Advocacy Competition 2026. We'll be sharing the brochure, the rule book, and the registration link in the chat immediately after this session. Do take a moment to go through them, and if this experience resonates with the kind of lawyer you aspire to become, we're delighted to welcome you. Once again, our heartfelt thanks to Advocate Sir Sahil Rathod for such an engaging and insightful session, and thank you to each one of you for joining us this evening. We hope to see you, many of you, again, but this time as participants in the NBAC 2026, because liberty deserves advocacy. Thank you, everyone. Thank you. Have a wonderful evening.
Thank you, NBSC committee, for sharing those details. I would like to ask, uh, tell participants if they have any questions they can ask from sir. The floor is open to the participants.
So we have one question Miss Vaishnavi has asked. How do judges evaluate rebuttal and sur-rebuttal and how can we excel in them? See, rebuttal and rebuttal basically is what is outside your memorial or what is, uh, for example, when you get when this memorial exchange happens, you get the arguments of respondent already. So now petitioners have that upper hand to argue your own case and put out the loopholes or the mistakes or anything whatever you would like to address in your own arguments. That is why every time it is said that petitioner does not have the right to rebut. It is only the judges who on the judges discretion. But respondents have the right to rebut because sorry, my mistake. Petitioner had the right to rebut and the respondents don't have. Now in rebuttal, what thing you should speak or argue, not your own arguments. Firstly, I had thought in my time that array, I forgot this argument, so I'll do this in my rebuttal or my sir rebuttal. It is not for that. Rebuttal, sir rebuttal is when you don't have any chance to cross question or argue on the opposite part's thing, then you have the right to rebuttal. And in that rebuttal, you basically point out their mistakes. So this is the thing. Next question, what to expect from first moot? There is a lot of thing to expect from the first moot. What the main thing you should expect is confidence, and winning losing you should not dive into that, in that pool, because unless you have confidence to participate in the moot, you won't step on the next stage. So for me itself, when I had the chance to appear in my freshers moot in my first year of 5-year course, I had registered and then I backed out because I thought अरे ये सब क्या है मुझे कुछ समझ में नहीं आ रहा. But then we got way our confidence. Then ultimately I enjoyed the moot courts so well that I participated in around 16 moot courts in my 5-year course, out of which I won 4 national moots. So this is what my journey took me to. Third thing is there repeat batch of whole program. This will be addressed by the collective council. Tanishq Thakur asks why one side is weak and one side is strong in a moot court. See, this is the in Hindi if you say जो मजा है moot court में. So this is the thing. If your case is weak, the judges are more interested in listening to your arguments, that how you are hiding that part and how you are presenting your case. It is, see, weak and strong is not appropriate word. We would say that uh, in a criminal trial, acquittal or conviction. So it is not weak or strong side which we can say. It is basically what thing or what facts are supporting the law properly. It is that thing. How you appreciate the law is the stronger side. Even if I am having the upper hand or I am having the stronger part in the moot court, but if I am not able to understand that part, I am at a weaker side, even if the facts are from my side. Uh, Somatya asks, Sir, as a researcher, what is my first duty? Research. Research it thoroughly, research it very properly, that you are well acquainted with what you have researched. Because, see, research part is something which is not in the mood proposition. You have set of facts, you have laws, you have arguments, you have everything. What thing you are relying on comes from the research. Justice K.S. Puttaswamy's judgment was it it is now, I guess, 30-40 years old, but the recent judgments which appreciate that judgment, if you refer that, is the fresh judgment, which I'll say a good law, because by time our judiciary is also getting into new things, interpreting the things from today's era. So I would say Justice K.S. Puttaswamy's judgment and today's judgment, which it refers, are two different things. So I'll always go with the latest judgments. Even in today, when I appear before the courts, I want to argue, I want to rely on thing. My first thing is, uh, so I'm basically practicing in Bombay High Court. So my first thing is I will search for a judgment which is passed by Bombay High Court. That is a mentality of the judges, that अरे ये इस यहाँ के कोर्ट ने पास किया है तो ये I can follow this. Next, go to Supreme Court judgments. And third, go to other High Court judgments. This is a part of research. Many a times it is not about law and facts, but it is about mentality and playing with the mind of the judge as well. Because everyone says, or we usually say, that judge is at trial. So you have to convince him. That is the only point that comes with your research. Ria Kaushik says, can I start doing moot court in my first year law student? Of course, you should start from the first year itself. You will be introduced to a lot number of hurdles which you will come on your own, and you'll have more experience or more knowledge about that. So where to start and how to research? Google is uh, what this generation has got for research. To go to Google, you have a number of articles on that. Then they have search engines, SCC Online, Manupatra, AIR Online, Live Law. There are a number of things where we can start your research. But before researching, read the referred law. If it is 302, read the section first, read the judgments, read the provisos, read the exceptions, read the law. Then you will have a clear mind that what I want to research now. Akhilesh Singh says, what I'm understanding, basically Moot could open up and remove fear from us and teach us so many things. Good, this is what we are trying to tell the students. Ritesh Sharma, which think most important in law, practical or theory? See, it is a coupled thing, I say, because if you do not have theory, clear theory, you will have nothing in your plate to put it practically. And if you read everything but you do not have practical experience, your theory will be your own theory only. You won't be able to deliver that. So that is a coupled thing. Shagun Sharma asks, so the precedent set by High Court or Session Court could be counted as primary source if no as such precedent set by Apex Court? Yes, if I am arguing before judicial magistrate, he is bounded by Sessions Court judgments, he is bounded by High Court judgments. If Supreme Court has not decided, now one thing, the live example I'll say you, which I am writing a paper on, Information Technology Act 2000, Section 67 and 67A. It talks about transmission of such information which is sexually explicit. And now, if you read the section, it does not talk about consent. Today, when two persons are dating each other, they are both adults, considered 23, 24, they are both adults, they are dating each other, and they involved into intimate communication on any of the medium, WhatsApp, Telegram, Instagram, anything. There is one point when they start sharing images. Now, these images are directly covered under sexually explicit content. These are directly there. You have GIFs, you have images, clicked images, anything. So, as per section there is a content which is sexually explicit. Second, there is a transmission from electronic mode, that is an offense. So now I am searching on this thing. While my search, I cannot find any Supreme Court judgment, any High Court judgment appreciating this law or discussing this thing. So this is new for everyone. So there are certain points as well when there are no precedents. Then comes your interpretation part. Riya Tyagi asks if anyone have WhatsApp group. Okay. Uh, Harshpreet Kaur. How much case law or other material can be required to support the argument? If that judgment directly answers your question, one is enough. Is it necessary to overwhelm the memorial with case law judgments, legal maxim, necessary to confuse the opponent? Confusion is not the main thing. Your own presentation and your good presentation is the main thing. Confusion will come in a very later stage when you have understood each and everything, you have appreciated the opposite memorial as well. Then you can find the loopholes that how can I confuse the opposite party. Third, how should we argue? I mean, just reading the memorial or making eye contact with judges and preparing all the arguments orally. Should not read the memorial at all. At all, should not read the memorial. You write it on a single page because what judges are expecting from you is that you know what you have written. So you should not read that. You should address the bench, not to the memorial. What if one side of the moot provision is, that is petitioner side is strong and respondent side is weak, then how to handle it? Winning or losing is not the part, as I repeated. And your client is not going to jail if you lose a moot court proposition. So you should not think that if I should win or I should lose or what I should think. The main thing is your presence of mind, your presentation, how you are exercising the entire moot court. Mm, difference between moot court and real court. Uh, how do I say? When I passed, uh, when I was in my final year, I won a national moot court. So I was confident enough that I'm going to litigation and I'll have good confidence. But my first appearance was before the Honorable Bombay High Court. I just wanted to inform to this court that we have been served the notice of this case on this date. We need time to file a reply. I was not able to do so because my heart was pumping. I thought that it will come out at any time. It was my first appearance before the High Court. So it is very, very much vast difference you can say. But ultimately, by time when you start practicing, when you go to courts, you see how arguments are placed, what is the etiquettes of the real court, in the moot court, you on your own will understand this thing. How to approach the case from the eyes of parties if I am petitioner to make my argument stronger. Because I am not able to understand your question. Um, Claude AI, Google Scholar, cases, judgment, etc. Do not use AI for research. The Supreme Court has recently imposed cost of 1 lakh on an advocate for using judgments created by AI, which does not exist. So that's it.
So, thank you, sir. As we come to the end of today's session, I would like to extend our heartfelt gratitude to Advocate Sahil Rathod, sir, for taking the time to share your valuable knowledge and practical insights on the fundamentals of moot court. Your guidance has certainly inspired our participants and provided them with the strong foundation to begin their mooting journey with confidence. Before you leave, we request everyone to kindly fill out the feedback form that will be shared in the chat box. Your feedback helps us organize more meaningful and impactful session in the future. Now let's take a virtual photograph. I request everyone to kindly switch on their cameras and join for a quick picture. Everyone, please switch on your cameras. Wonderful. Thank you everyone for joining us today. We hope you to see again in upcoming sessions. Have a great evening ahead. Stay connected with the Collective Council. Thank you. Thank you, sir.
Thank you.